5 seconds to go. Start. The detailed examination of the codes of criminal and civil procedure was deferred as they were likely to consume considerable time. After the Law Commission submitted its 14th report on the reform of judicial administration in September 1958, the government asked the Commission to undertake an examination of the Code of Criminal Procedure. When the Law Commission was carrying out this exercise, the Parliament enacted the Anti-Corruption Laws Amendment Act 1964, Act 40 of 1964. By this act, four different acts, namely the Indian Penal Code 1860, the Code of Criminal Procedure 1898, the Delhi Special Police Establishment Act 1946, and the Prevention of Corruption Act 1947 were amended. Three important changes were made to Section 198B of the Code of Criminal Procedure 1898 by this Act 40 of 1964. They were the brackets and words other than the offence of defamation by spoken words in subsection 1 of section 198b were directed to be omitted. After subsection 5, a new subsection 5a was directed to be inserted as follows. Every trial under this section shall be held in camera if either party thereto so desires or if the Court of Session so thinks fit to do. After subsection 13, a new subsection 14 was directed to be inserted as follows. Where a case is instituted under this section for the trial of an offence, nothing in subsection 13 shall be construed as requiring a complaint to be made also by the person aggrieved by such offence. The version of history that could be traced from the amendments made in the years 1943, 1955 and 1964 to the Code of 1898 can be summed up as follows. The Code of 1898 enabled under section 198 only the aggrieved person to file a complaint. The amendment of the year 1943 carved out an exception in the case of women who could not appear in public, minors, lunatics, sick and infirm persons, etc., by enabling them to file a complaint through some other person. The amendment of the year 1955 prescribed a detailed special procedure to be followed in the case of offences under Chapter 21 of IPC committed against the President or the Vice President or the Governor or Raj Pramukh of a state or a minister or any other public servant employed in connection with the affairs of the Union or of a state in respect of his conduct in the discharge of his public functions. But this procedure was not applicable to the offence of defamation by spoken words as seen from the words any offence falling under Chapter 21 of the Indian Penal Code, Act 45 of 1860, other than the offence of defamation by spoken words. But the words other than the offence of defamation by spoken words in section 198b1 were omitted by the amendment of 1964. It was from this milestone that the legislation moved to section 199 of the Code of 1973, which we shall see later. After the aforesaid amendment of the year 1964, the Law Commission submitted its 37th report in December 1967 on the Code of Criminal Procedure 1898, but it covered only sections 1 to 176. Paragraph 525 of this 37th report indicated that the sections of the code after section 176 were proposed to be dealt with in later reports. Therefore, the revision of the remaining provisions of the Code of Criminal Procedure was undertaken by the subsequent Law Commission constituted in March 1968. This commission submitted its report which is the 41st report in September 1969. Interestingly, it was recorded in the introductory chapter of this 41st report that though the first 14 chapters of the code have been exhaustively analyzed in the previous report, 37th report of the Law Commission, the Commission was compelled to revisit even those recommendations. The reason for this, according to the Law Commission, was that a finally integrated and comprehensive law like the Code of Criminal Procedure cannot be revised piecemeal, as the amendments suggested in one part of the code were likely to naturally affect provisions of the other parts of the code to a greater or lesser extent. Therefore, the 41st report became a very comprehensive report. As we have seen in paragraph 14 above, the Code of 1898 contained a provision in section 198 which mandated that the cognizance of offences relating to breach of contract, defamation, and marriage cannot be taken by any court except upon a complaint made by the aggrieved person. The 41st report of the Law Commission recognized, as seen from paragraph 15.131, that section 198 of the code dealt with the issue of cognizance of three completely unconnected groups of offences, namely offence relating to breach of contract, to attend on or to supply demands to helpless persons, offences relating to marriage, and offence relating to defamation. Stop.